Alrighty. Thank you all for being here. At this time, I'd like to call the meeting to order. Looks like we have 2 board members in the room and 2 calling in, so we should have a quorum. Has everyone had a chance to review the director's decisions, the violation resume, warning letters, inactive status letters that have been presented to us?
Yes.
Yes.
Okay. Do we have a motion on those items?
I'll make a motion.
I'll make a motion to approve. Oh, sorry. Go ahead.
Right. I'll make a motion to approve the fines and directives. Is that correct?
Director's decisions, violation resume, and warning letters.
Thank you very much. I should have let Susan do that.
And I'll,
Okay.
no, you're good. And I'll do the second. How about that?
Thank you, Susan. All right, we have a motion and a second. All in favor?
Aye.
Aye. Missing 1 vote. Do we need 4?
You don't need 4, but Hannah, you are on mute just in case you were trying to vote. She may be distracted, but.
All right, well, we got 3. We're good.
3.
Yeah.
Okay, great. Thank you all for that. This time I'll hand it over to the director for an ABC administrative update.
Okay, we've got a short PowerPoint for you, but as I was telling everyone who's here in person, Susan, I have a large stack of legislation, so I'll go into as much detail as we can where y'all want. Okay, first slide. We have changed our seminars to the first Friday of the month. I think that's working. This month we have 50. Next month it's May 2nd. We'll keep doing that except for July 4th. All right, we had 32 offers accepted covering 96 violations, 3 warnings, and I will highlight 1 revocation on the ABC side. So not going to talk too much about it in case they appeal and it comes to y'all. You'll have fresh eyes for the facts if they do. If not, and it's not appealed, I'm happy to give a rundown next board meeting or the following about why we chose to revoke and kind of what facts were going on the list of that decision. Outside of that revocation, though, we offered fines in just over $20,000. We have a couple more directors hearings scheduled out till June. The last bullet point is a little bit of a new one for you guys as well, because it was a new one for me. Since I have been here, we have not had a wholesale change request. Basically what happens, there are assigned wholesalers. If there's a disagreement, business reasons have to be shown why they could change their wholesaler. There was a director's hearing and a decision was made to allow that wholesale change request. Again, I'm not going to go too much into it because they will have the right to appeal. And so that could ultimately come to y'all. But I will say the reason why it's on the PowerPoint is our rules, again, ABC rules are so complex. There's different procedures for different things. For some reason, this one doesn't go on the resume, but I'm supposed to notify you all about it. So here's your notification that a wholesale change request hearing occurred. On the MMC side, we had 1 director's hearing. We have several coming up through June. So we got 1 offer and 1 violation out. Just a little $500 easy peasy one. I know I've got 4 or 5 more to sign on my desk. So that is probably why that number is not quite so big, because they're waiting on my signature. Okay, legal update. We just said legislative session. What I have brought here today are all of the bills that have been signed by the governor. There are a few more who are already in the queue. But because she has not signed them, we just kind of minimalized it to exactly what we know is for sure going to go into effect. Session ended today. This is my first session, so hopefully I don't say this procedurally wrong, but it's my understanding that they are still open to basically be called between now and May 2nd, May 5th, something like that, in case there is something the governor refuses to sign and they have to veto override, anything like that. I don't want to speak specifically to the technical because I'm not exactly sure, but there are situations where that could happen. But essentially the everyday committee meetings, the everyday filing bills, that part of session is done. So I will start, I think these are kind of in the most recent, going to the oldest ones. So ABW on beer. This bill finally passed. The first time they filed it, they wanted to up the percentage in the definition of beer to 14%. Is that right? And they landed on 10. they kind of got beat up on the floor.
What was it before?
14%.
No, like before this bill.
Oh, 5.
Okay.
And so the behind the scenes, what this piece of paper doesn't necessarily say, but what the effect of it would be is that grocery stores could sell craft beers, the higher ABW, which is alcohol by weight. Every other state in the country except for Utah, I believe, had upped their percentage for beer alcohol in the last several years or over the last several decades. So the beer industry felt like we were a little bit behind on this. They shot for 14. There was a little bit of negotiations, like right before House Rules one day with some of the liquor store guys, because the liquor store guys wouldn't be able to sell these craft beers. And their argument is, we only sell booze. A grocery store, you guys sell snacks, you sell groceries, you sell other stuff. We only get to make our money off booze. And so the beer guys are like, well, we want this to pass. So there was a little bit of discussion about, can you bring down your percentage? Agreement wasn't necessarily made, but then after spring break, a new bill was filed that brought it down to 10. And I think there was discussion between all industry members that that was a good move. So this ended up passing relatively quickly with less discussion than the first bill that was filed.
These all go into effect 90 days.
I believe so. Some of them may have emergency clauses. Some of them may have specific effective dates. So it kind of depends on the way the bill is written, but generally speaking, I believe so. Okay, the next one, this isn't necessarily alcohol specific, but there's overlap. Alcohol permitted premises are not allowed to have gambling unless you have a casino license under amendment 100. Which is not technically an alcohol and ABC license. It's like their own license to also drink. That's why you can drink on Christmas Day at casino. Anyways, so the overlap, casinos are moving away from greyhound racing. And so this, we've seen several bills this session. One was to delete the language just to kind of clean up the code. Since we don't do it anymore, let's not have it in there. But this one is actually a bill to prohibit it. So this one actually has an interesting effect date. It says it prohibits not only the physical racing of greyhounds, but also simulcast. So this has an effective date further than the last state, which I believe is either Virginia or West Virginia, that is doing greyhound racing. So this has an effective date of like 2028 because they're waiting until every state in the nation has phased it out to make it specifically legal for simulcast here. So that passed. It wasn't very controversial. It looked like it passed pretty quickly based on my notes on the side. This one, not super sexy. There was a report that ABC gives to the Secretary of DFA, and the Secretary of DFA gives it to the legislature. This just repeals the requirement for us to have to get that report. It's something that I think had kind of phased out over the years anyways. Not a lot of our staff really knew exactly who was compiling that report. Nobody over at DFA really knew who was asking for it. So clean that up a little bit. This one, 365, this will allow someone who has a small brewery license to operate 3 tap rooms. Previously it was 2. So quick change there, but I think a change that a lot of people are going to be happy about. Josh Bryant asked us to run this for a constituent that he had in mind, and he worked with us to make sure that we didn't complex. We pull one pull thread, it complicates a bunch of other permits. So he worked with us to make a change that was practical, but that didn't really mess with too much other stuff. Okay. 1455. This one had several amendments. It started out allowing private clubs to buy from wholesalers. Then it changed pretty quickly from industry pushback to allow, well, and let me go even further. The sponsor of this bill contacted us to resolve a specific issue with some constituents in Clarksville. And because they have very complicated dry county private club laws, there was a way that someone wanted to do their business where they were brewing their own beer in their own, I think it was microbrewery or small brewery. And they wanted to be able to sell that to themselves, but because you're in a dry county, you have to buy from a retailer. So they were having to buy their own beer back from a retailer in one area. So this bill allows them to, it's very specific. It started out wrong, but it has been narrowed down. It allows them to buy from a small brewery wholesaler who they have an exclusive agreement with if the private club is in an entertainment district. So it basically solves their problem, but it also does allow if someone were to have a manufacturing, which it gets complicated because it's only certain manufacturers because of exemptions within a 3-tier system. But if they were to try to have the same setup and they didn't want to have to buy at retail their own product that they manufactured and they have to be in the dry areas, they could petition their area to get an entertainment district. They can enter an exclusive agreement with the manager of the private club and they can sell their product directly there. So it's very limited because the industry, distributors have wholesale rights over certain products. So this kind of allows them to do what they want to do without messing up the larger framework. Okay, this bill 345. The idea behind this bill was again dry counties, complicated to sell alcohol and buy alcohol in dry counties. And my side on this is it would be a lot easier if they were wet. But instead we've got legislation to just complicate it up a little bit more. So now private clubs are not going to need to have nonprofits attached to them. This came up because chain restaurants had to file multiple tax returns, and they don't want to do that anymore because of the different nonprofits associated with each private club. So this bill also kind of had some phases. There was another bill that created a separate private club permit for large restaurants, and it took away the nonprofit requirements for them, but it was silent as to the other private clubs, which might have fewer than 100 seats. So it got a little complicated. So then this bill came back and undid what that bill did and said, okay, we'll just do it for everybody. So now no private club will need a nonprofit, and that will hopefully ease the tax process for some of these chain restaurants.
Why was the nonprofit put in place to begin with?
I can't necessarily speak to the intent because it is so old, but I can give you my best guess. Historically, they have wanted to keep certain areas dry, but as the state got more populated and they wanted to bring industry and business here, people allowed social clubs or country clubs or types of associations for specific reasons. And then that kind of just got diluted because people want to drink.
So it's archaic.
So it is, and there are lots of modernizations that can be made, but Arkansas, from what I understand, historically has some just deep ties and some agreements between different sectors of the industry to kind of let things lie. And I will get to some of the local option elections and how this session made it a little bit for certain areas to decide to go wet if they wanted to. Well, to collect signatures might be a little bit more difficult because there are more steps to take to get the signatures on paper. So private clubs are going to be a thorn in our side always. Anybody who lives in a dry area is going to be confused by the rules because I have really good attorneys and really good agents who are also confused by the rules. And I consider myself a pretty smart cookie. I am confused daily by the way things are put in our rule book. So bear with us as we figure out what rule promulgation is going to look like. There are several approaches to rule promulgation too. Get it done. You got to get it done by a deadline. You have to do rule promulgation as to every bill that requires it that's passed in session. I think that was over 10 last session when Drew and I were both brand new when we returned right after session. Well, we really didn't even return after session. There was time. Nobody was here as director to do it because we had so many interims. So Drew and I had to kind of pick that project up and muscle through. This year, much more is expected of us. A lot more has passed, and there are a lot more rules that will need to be promulgated that don't just match what's on paper. They'll have to actually be thought out to make what passed on paper make sense.
So will we do one batch of rule promulgation for all the bills?
We don't know. We may have to break it up because it's going to be so large. So there may be a list, and we've kind of worked on it as a staff already. There's going to be have to get this done. This has to be cleared up right now, and we already know how we're going to fix it list. And then there's another list of what does this look like? Maybe we'll try to do some of the easy ones and some of the hard ones and then pass that batch. Maybe we'll try to do all the easy ones, just get that passed immediately. all the things I said we were gonna figure out after session, today is the last day of session, so it's time to figure that out. I don't know exactly what that's gonna look like, but we've been keeping lists so that we can at least know once things pass, what is it gonna look like? I was having a discussion with Ray yesterday, chief of staff, about one of the certain permits and what they require and what to put in RMS. And he was thinking one thing and I was thinking another thing, and we're like, oh, okay, well, we need to look in deeper on this because some of it's gonna be brainstorming. I just hadn't considered what he was thinking was the most logical way to do it. And I was like, oh, yeah, well, that makes sense. So some of it is gonna take some time, especially this project club, because we wanna make sure we don't contradict ourselves, which has happened in the past, which is why our rules are so complex, because the statute will say one thing and the rule book will say something ish the same, but not always.
I would say try to knock out the easy ones first, just to get something off your plate. You've had a lot going on the past couple months, and then it's, it's an easier argument to be like, well, we haven't gotten to these because it's more complicated. We want to do it right, but you can show progress has been made, in our.
Yes. And I will say too, it is difficult sometimes, but ABC is probably going to be the most, but we've also got ABC, MMC, and some tobacco ATC rules that will need to be done too. So our attorneys will be working kind of in their areas, but also depending on how much needs to be done, we'll kind of have people sub in and out, and all have to be instrumental in that process as well. But then this brings me to another kind of regulatory thing that's not exactly related to us, but it came through ABC because ABC permits are not allowed to do gambling. And everybody loves the Razorbacks, go Hogs. So this is the sports raffle for NIL. There's lots of discussion about this somewhat early on in session. I don't know if you guys followed. It was sponsored by RJ Hawk, and the prerogative was to allow universities to hold raffles to raise money for education programs related to sports athletics or sponsor scholarships specifically. There were a couple iterations and amendments, but ultimately that passed. The opponents of this bill will say that it's not going to raise much money and that it should be done through casinos. If you could guess who the opponents of this bill may be, there are people who work for casinos. So that one was kind of interesting to watch, but not totally related to y'all, but it got tossed on our desk for a fiscal impact statement because it specifically has to create an exception to the ABC laws to allow them to do this type of gambling on an alcohol permitted premise. This one's pretty easy, and this is supposed to help out people in dry counties. Microbrewery private club advertising. This will allow them to put on social media, website, or other electronic means providing information to a consumer regarding the microbrewery restaurant private club, including without limitation, location, events, and menu. There's a prohibition against advertising the consumption of alcohol in dry areas. What's the catch? There's no legal definition for advertising. So every director's had different interpretations about it. It's a gray area for the agents as well, because they're like, oh, well, is this advertising or is this somebody reposting a review that somebody wrote on their own personal Facebook? It gets real complicated. This just kind of clears it up for those people. You can put your location, you can put your events, you can put your menu, so people know it's not like a secret what's in the building. They know what they're going when they go to eat there, so, or what they're going to get. So I think that was probably a smart move to just have that laid out specifically. Switching over to marijuana for a second. This is the processed marijuana final product rule or legislation bill, I guess. It had a few amendments. There was a little bit of pushback. This went through agriculture committee, which was fun for me because I went in there and everyone was wearing a cowboy hat. And I was wearing like a hot pink blazer. And I was like, well, I'm not in agriculture committee very often. So this one was fun. But they had to change some things. What the proponents of this bill were very clear to say was that they were not pressuring ABC or MMC into allowing for pre-rolls, but that the passage of this legislation would allow us to change our rules to allow for pre-rolls. The reason why is because there's a previous interpretation that the paper is paraphernalia, and the paper that was wrapped around the pre-roll was not allowed to be sold out of a dispensary because it was paraphernalia. So this changes that and says that once a green leafy product essentially is wrapped around something that is paraphernalia, or in the case of a cartridge, if a distillate is put into that cartridge, at that point, that becomes a final processed product. So we're no longer talking about pieces or paraphernalia. It's not paraphernalia at that point. It's part of the product to be sold. So this opens the door wide open for the division. And I'm not sure specifically, Chip would know better than me, if that's under ABC rules or MMC rules. Some of the operation, I think, is under ABC, and some of the licensing rules are under MMC. So that'll be rule promulgation. We'll have to look at the whole stuff that I'm sure people from the industry are going to be calling me about, wanting to know where we all land on it. So that'll be an interesting one. This one,
So the jury's still out on if y'all would support a change in the rules to,
yeah, I think I'm gonna need to speak to some people in some other executive offices of the state, and also probably Secretary Hudson on that one. They made it very clear. They kept saying, we don't want to stick anything in. And then they got questioned by the table, is this for pre-rolls? And they're like, not necessarily, but it gives the opportunity if they want to. So it was pretty interesting to watch. And I do believe that they weren't necessarily misleading about what the bill does at this point. It does give us the opportunity to do that. However, lawyers can differ on every kind of legal opinion. Amendment 98 can be interpreted several different ways. And there are some people who would say that there could be anything of an Amendment 98, regardless of what this says. So we shall see. It will be a fun next couple months, I'm sure. This one is a tax bill. It's a marijuana tax bill. There was something in the original bill that sunset the collection of this tax. So this repeals that sunset. So that's the we're talking to continue collecting this tax. Okay, unsealed marijuana in a car. I forgot about this one. This one was pushed, I believe, by the Northwest Arkansas police agencies. It has to do with, and I only know some of this because I'm a prosecutor, or was in a past life. It has to do with kind of the grab area of the marijuana in the vehicle. And Potter can start talking if he wants to. I've been talking a lot, but basically it has to do with if there's a patient and a non-patient in the car, and there's a product in the car, and officers pull you over, and they're like, well, who do I attribute this to? Like, are you giving it to this person who's not a patient or not? So it kind of codifies a specific area within the vehicle that may or may not be used to prove that it may belong to one person, which has to do with.
It draws correlation to tobacco, same areas, and also public roadways and things of that nature. So
Yeah, it does say it's unlawful for a person to possess an unsealed container containing medical marijuana in a vehicle that is located on a public highway or the right of way of a highway if the medical marijuana is in a form that can be readily used and it is within the area of the motor vehicle that is designated to the seat of the driver or the passenger, or is readily accessible to the driver or passenger in a motor vehicle in a seated position.
So give me that in layman's terms.
you
So-
can't be smoking a joint
And driving a car
or riding in a car.
or riding in a car. And it makes
So
the
if you're a
distinction.
patient and I'm not a patient and I'm in the passenger seat and you're the driver, there's unsealed marijuana between us.
That's breaking the rules now.
Well, and it's
If it's
not
really
necessarily-
easy to consume.
So, and practically speaking, it's really only going to happen in this limited circumstance when the officer shows up and needs to figure out who this belongs to because potentially there's an arrest. That happens now with illicit drugs and guns all the time. It's called constructive possession. If you guys are both in a car in the front seat and there's a gun in the glove box and we don't know who to attribute it to, oftentimes both of you, especially if you've got history, are going to get put in jail. And then the prosecutor is going to get a file with a bunch of other legal facts and statements, and they're going to have to try to figure out, do I charge both of you or do I charge one of you? Da 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 da, maybe. And then to make it even difficult, let's say the gun has the initials AB carved into it. So now which one of y'all is it? So it's just kind of like that with weed. So it's a standard premise that already happens. It's had to be thought out.
there is some movement nationally to throw out the search warrant exception clause for search and seizures of vehicles. And so among the things that this does is this gives an arguing point for Arkansas to maintain that, whereas we're not throwing out the search warrant exception for moving vehicles, which is clearly defined in law. So there was a recent state that was Illinois that threw that out. Basically, the Supreme Court ruled that the odor of marijuana in itself was no longer probable cause to conduct a search. And so this does a few things there, but it also kind of solidifies Arkansas's stance there. I think that this legislation will be used in a further Supreme Court ruling at some point. So I think it creates the legal pathway to make that stance. So this was pushed from Northwest Arkansas Law Enforcement Agency. And then some of it is just the practicalities of people smoking medical marijuana on the roadways. So it kind of does a couple of different things.
But if you're on a private road, it wouldn't affect, our private property. This law wouldn't really.
So it's under the definition of a public place. So to generally answer your question, if you're in your property behind a gate on a road that is not maintained publicly by the county or the city or something of that nature, I would tell you that problem does not apply if you were on private property on your own road.
And this is where we get the fun, like, it depends answer too, because the officers, it's totally dependent on the facts and circumstances as their boots on the ground looking at it. So sometimes they do want legislation like this because it provides clarity for them and when that situation comes up. But then, like, from a legal perspective, I know 6 different prosecutors who could have 6 different rulings in that case. I mean, it's always going to be a call.
I think that Fourth Amendment exclusion is going to end up ultimately at the Arkansas Supreme Court at some point in time. That's my opinion.
But again, it's a case by case, and it also depends what other substances may be in the car, what other things, what other behavior. So when this was filed, we did get some questions from several people like, are y'all pushing this? We were like, no, but kind of do understand where it's maybe coming from. Okay, now I think I'm to the ones that y'all have heard a little bit about, but just to reiterate, boat excursion, paddle boat, coming to Little Rock, Yeehaw, that should be fun. Liquor store quota. This is the one that will allow people to own more than one liquor store if they own them in the 3 most populated counties in the state, which are Drew, Benton, Pulaski, and Washington.
Anything over 200. So if some other area of the state decides to boom for whatever reason, that would fall into this as well.
So,
And you could only have one in each.
So yeah, based on population. Also, in other news, not to jump around, but are there some lotteries that we may need to be doing?
Based on the 2020 census, we will have to issue some new permits in, I think, 6 counties, 5
So-
counties.
If y'all didn't hear Drew, based on the 2020 census, we may have to issue some new liquor store permits, which will be fun because those are done by lottery. No one has to make like a judgment call. And I know maybe some of you have heard MMC stuff where there's no scoring to license. This is just drawn out of a hat kind of vibe.
Who gets
So-
to draw?
Maybe you. I honestly don't know. Maybe Randy did the last one.
They draw themselves. Like we put numbers in a box and they draw a number out.
They pick their number.
They pick their own number.
But I mean, then who picks the winning number?
Well, there's just an amount. It's like if there's 4 available, so whoever
So
gets
we get
Yeah.
numbers 1 through 4.
Yeah. Like there's 8 that apply. Whoever gets 1 through 4 would.
There's
be the-
one drawing.
Oh,
My understanding, there's one drawing where you pick your number in line to do the actual draw.
where's that done in?
Here,
In during a meeting?
yes,
ABC meeting?
yes.
Interesting.
It'll be fun too because some of this y'all are seeing for the first time. That Drew and I are seeing it too. So we're like, Brandy, what happened 10 years ago when it happened?
I like the
we
little
know.
bingo ball.
Yeah, so that'll be interesting. But based on
The
the
chairman change that? Can we change the way we do the drawing?
we'll see. I mean, if it's not specifically in rule that says the exact way, I mean, we can work within the confines of the law to do it how you want to do it. But I'm actually kind of interested to see that happen too. I've heard about it. And again, moving back to it's based on population. So counties get as many liquor stores as their population might allow for. However, the hitch to that is before this regulation was in effect, some areas have a lot of liquor stores. So it's my understanding that like Pulaski County, even if we keep growing in population, we're not going to need to do a drawing because we already have too many from before that law was set in
It
place.
was 1 for every 5,000, and now it's 1 for every 7,500. So Little Rock already has too many and there's also a thing in there about cities with over 200,000 people. So Little Rock, like if you move your liquor store out of Little Rock, you can't come back in until that population catches up with the one in 7,500. So it gets pretty complicated.
Everything in alcohol is complicated. And we knew that, and we really did know that until legislative session drew where I was like, this is why it's like this.
Mhm.
Because everybody's just sticking amendments in there, and this industry person talks to this person, and then the dry area is really, it's been so manipulated over time that it's kind of like,
Is it really even that drug?
what is a private club at this point, to be quite honest. Okay, moving to the end, paid canvassers. This is one that I was getting at that will make it a little bit more difficult to go with because it has more restrictions on who can be a paid canvasser and what they have to say or read or do to obtain that signature. It also sets out violations for people who don't follow those rules. So it's not going to make it impossible, but it is going to make it a little bit more difficult just because with more rules, there's more stuff you have to comply with. Okay, and then this big fat one, third party. This is the one that, thank goodness, before session, we were kind of like, why are we all talking about this? Like, session hasn't even started yet. Thank goodness. Drew and I were given a little bit of a heads up on this one because it was a little bit controversial. Thank goodness it was right at the beginning of session when everyone was fresh and could really look and give input. So this bill, it had opposition, it had support, it had lots of dialogue around it. Ultimately, it passed. There were several practical issues that we worked with the industry on before it was even filed. And then after it was filed, more things came to our attention or more discussion in committees had a few amendments. This does give us rule promulgation authority. This would be one that Drew and I luckily are the most in the know about and feel really confident that we can promulgate rules that make this make sense.
I got a question on it. And I was always scared to ask this while I was all in the play because I feel like this is what I would be thinking about if I was the Walmart or Amazon's.
Mhm.
But when you layer in the 3 liquor store options now, if are Walmart and Sam's Club under one group?
That's a good question. I mean,
Because like
do any Sam's Clubs have permits from us, or are they all just Walmart
They do.
marketplaces?
They do have-
Sam's has it.
One group is in what you mean, like,
Oh yeah, 'cause
So-
Sam's has one.
It's
like,
it's all owned by
Walmart have
Walmart.
3 liquor stores in the state, and Sam's Club have 3 liquor stores.
I get what you're saying.
I don't think so.
No,
I think because there's already the liquor store in the Sam's Club in Fayetteville, that counts as their one in Washington. So Walmart will be looking at where to put one in Benton and where to put one in Pulaski.
So my question would be, if I go on the Walmart.com app, which I'm on like 3 times a week, I feel like.
Is that Walmart Plus?
So,
Yeah, that's an added thing where you like, free delivery.
Because that's what I think this may funnel through. My
Okay.
fiance was
If
like,
they're-
"I'm in Walmart Plus," and then I was like, "Is this overlapping with work right now?"
It's like Amazon Prime. Like you pay like a monthly membership for. The question I'd have is like, will I be able to go like on the Walmart app, Walmart Plus app, and be able to buy beer and liquor delivered, or is it just beer?
No, it won't be everything.
It'll be everything, and even if it's, so technically what would happen like in Fayetteville, I could be on the app and I could go to my cart and add a bottle of Smirnoff vodka, but it would just have to, from the logistics side, it might end up being 2 deliveries because they're not both from the Sam's Club in Washington County. And then my other food delivery, would come together, 2 separate people drop it off as one order at the house.
Maybe.
I don't know how they
And
will
that's
do it.
where we like to giggle and say, that's a Walmart problem.
Yeah.
It's not the only problem if we're actually doing something outside of our restrictions, but I'm sure we will get a call to help them practically figure out exactly what that looks like. But yeah, it sounds like maybe
They already
Yeah,
have their own,
separate.
because they do this in other states already, so they already have their own system. I think it's called Spark, where it's like an Instacart basically for specifically just Walmart. So that's what they will do it under.
Yeah, I've seen like the Walmarts like when I'm in other cities where they have beer and wine that you can just add to your cart on your phone or your computer, but I've never seen it with alcohol.
Well, and the liquor store will have to be separate as well. So if you've ever been to the Costco in Little Rock, there's the front door to go into the main Costco, and then to your right is a door that says like liquor store. And there have
Yeah, that's the same with the Sam's Club in Fayetteville.
yes, the same
But
thing.
you know what I was Yeah. Oh, sorry. Go ahead.
Oh, that was it.
No, go ahead, Susan.
Well, I was just going to say, and maybe this is more on the Walmart business side, less for us, but I know just what you're saying, Alex, like where we live in Northwest, that Sam's Club in Fayetteville doesn't deliver to us. You know what I'm saying? Like our orders come from the one in the store in Bentonville, which does not have the liquor store associated with it. So how do you service customers who are outside of that store's delivery range? But I think that's more on the Walmart issue. Legally, there's no restrictions on how far the distance between a customer's home for the delivery and the store location, correct?
Well, I don't know, can you deliver into another county?
Yes, so
That would
this
be my
will
question.
allow you to
Yeah.
deliver into a border county that is, wet.
What if it's dry?
No.
No. We'll be checking.
Yeah.
I did not know that you could go across.
That's the big thing is we're simultaneously, if I can just go on my soapbox for a second, we're simultaneously allowing these dry pockets to exist, but then making it easier in all of the wet areas to access it. So it's still creating this desert for the dry areas. You don't really get to benefit off this. One of the ones I didn't mention is direct to consumer wine shipping. Y'all don't get to benefit off that either. As far as dry counties, you can only ship into a wet county because of overarching regulations as far as wet and dry areas.
So that wasn't in your stack, I'm assuming it hasn't been signed yet?
It hasn't been signed yet, but is passed. Yeah. So
And for that one, it was like, what, like, you could get like 3 cases a year?
there were a couple amendments on that one. I ultimately think it ended up with using some sort of phrase like personal consumption amount. I think it took out the specific, but then I think there might have been an amendment that put it back in. To be honest, it gets real blurry
Yeah.
here with the ones that had 3 or 4 amendments at the end.
Is it 4 cases of one specific type of wine or just 4 cases total?
I think you just said total, but it will be coming from like the one permit holder, I guess. So
How would you track that?
It'd be really hard to track.
On the ABC.
'Cause I mean, if you went to 3 different websites, how would they have some like unique identifying number for
Yeah. And
Yeah.
if
like, let's say a husband and a wife at home? The double.
even if
What are
we
you
had-
interested in enforcing? The consumer or the retailer?
we couldn't enforce
Yeah.
the consumer.
even if we had 300 agents and 60 attorneys, it would still be complicated and we would still find avenues to explore within this agency. So I think it's been eye-opening for me, and I think for Drew too, to see like, oh, when we read the law, we're like, this is why it's so confusing, because that was pushed by a specific person who's looking at it from one point of view. And then when a wholesaler hears about it, they're like, oh my gosh, I have the exact opposite point of view. So then there's all this pushback, and then there's compromise, and then you end up with something that kind of works a little bit, and then sometimes you end up with something that the agency's like, what does this say? And Potter and I are like, how do we do this? So then that's where rule promulgation comes in. So it'll be a busy couple months trying to figure out what exactly
Yeah.
practically all this looks like.
Do you have a requirement in how quickly you have to do rule promulgation?
We were on the naughty list for over a year. So when I showed up here last time, we were already several months late. So do you necessarily, what happens if you're late? I don't know. I think you just get a bunch of really annoying emails that are like, do these, and then you have to go to ALC and tell them why you haven't done them. So we will not be late this year, if at all possible.
I would just get as many of the easy ones done so you can show that you're making progress, but like, hey, like the wine delivery is gonna be a mess, or the third party delivery, like, you know, it's easy to make an argument for these, like it's such a drastic change from how things have been before. You don't wanna like come out of the gate and
I
wrong.
will tell you guys, it's rule promulgation is a lot of hoops to jump through. You've got to talk to the newspaper, the Secretary of State's office, BLR, and just internally. So there's a lot of hoops. There's a lot of dates that has to be in.
The timelines are
It's like
That must be approved by the legislature too. It has to
Yeah,
be.
it's like,
So
it's gotta go back through the legislator.
But you have to do all of those other hoops before it can even get in front of ALC.
And then when we get there, they're going to grill us as they did last time about why are you doing this? And we're like, well, we're doing this because the legislation told us we had to do it. But then heaven forbid you want to And it gets real nuanced too. We were also new last time. I think we could probably do it better this time. You don't want to just mimic what that says because that's not helpful. So you actually want to provide guidance, but you're not allowed to rule make outside the confines of what the law already says. Then there's also the industry already is approaching me about new ideas. Last year, when we were in the middle of rule promulgation, the industry came and asked for earlier delivery time for distributors, and we were able to tuck that in with these. The industry knows that we're working on rules, so they're going to come knock. Hey, while you're doing that, can we also talk about this? So it's going to be a process.
I've also been keeping a list of things that could change in our rules or should change in our rules, so that will also be part of this. There's some stuff in our rules that should have been changed due to previous legislation, I don't know, 4 sessions ago that didn't get changed, and so that's why it conflicts with the statute, our rule does. So I'll have to change those to go back to what the statute says. So it's going to be more than just that stack.
But that is a perspective shift when we start looking at like, oh my gosh, this is gonna be so busy. It's also an opportunity for us to clean up some things that we've seen that have confused us. We're like, why does it say it that way? Well, we're gonna add that to our list to try to provide more clarity. Ultimately, when Drew and I are not here, we want whoever picks up the rule book to think that it looks better than what it looked like when we got it.
Which you're never gonna like.
No. But if that day ever were to come, then. But yeah, that's really all I got. I know it was a ton of talking. I'm sorry about that. If you guys do have specific questions on something in your area, as always, please reach out. Sometimes Brandy's the best person to reach out to. Sometimes it's Drew, sometimes it's me. But if you holler at me, I'll make sure it gets wherever it needs to go.
One quick question. There is the Purple Cow in Benton.
Oh, Brandy, I forgot. Did I
Does that-
approve condition? Yeah.
Sometimes when we've done those in the past, sometimes that was like a separate motion for special consideration. So I didn't know if we had to do that or that just went through.
It just went,
When I was new and I didn't know what I was doing and I asked you to do that, but we don't we need to do that.
Okay, I think it happened with Dorley once, but
Or, well, maybe I'm doing it wrong.
that's fine. As long as it's in there.
It was on your resume. As
Yes.
One of the approved or approved conditional that you guys have now approved for the 30-day consideration. So that
Yes.
should be good.
Good deal. And then I guess maybe next month we'll have more info on the wines and the other ones.
Okay, this is the other thing. Sorry, y'all. Drew mentioned this briefly before. With direct-to-consumer wine shipping, it strikes a bunch of the small farm winery language. The small farm winery is one of those that we do a lottery. Because a lot of that language is struck, we again have a specific legal timeline of when we needed to do that. So we've moved the June meeting from the 25th to the 18th. No, also the opposite. We moved it from the 18th to the 25th. Here's the holdup. I think Jamie was going to be out of town that week. So our question is, do you guys want it on the 18th or do you want it on the 25th? But kind of Jamie's the one who might have been the determining factor on that. So I don't know if y'all want to leave it. I don't know if you want to change it, but I will say it is helpful to the industry, but we can give them as many more dates set in stone at advanced time as we can.
I don't have an opinion.
Right now it's on the 25th.
But since that we're not going, it's gonna be moved. That small farm wine shipping permit lottery is moved at this point. If the governor signs that bill that passed. So we won't have to stick to that timeline. Can be the 18th. I know Jamie is gonna be out of town the next week on vacation, so
Maybe can do the 18th or the 25th.
the 18th.
Right. So yeah, I mean, I'm moving to the 18th.
Y'all want to move it back to the 18th? That would be our
Original date.
Susan, is that okay with y'all?
June.
Oh, I'm sorry. Go ahead.
June 18th versus June 25th. Any issue with your schedule for summer?
Either one will be fine, honestly.
Okay.
So whatever
If
works best for the group.
If we move it back to the 18th, that just keeps us more in line with the, what is it, the third Wednesday, which gives the industry that 30-day posting period. So I'll go ahead and put it back to the 18th. So that has us at May 14th, June 18th, July 16th. If we want to set August, it would be the 20th. That could very well be the first day of school. I don't know if y'all want to go that far.
yeah.
So have we set July? Did you say the 16th?
Yes.
Ideally, I'd like to avoid the first week of school. And I know, Alex, you have school-age children as well, so I don't know if that's a challenge for you.
Y'all want to
But-
wait till the month maybe and just don't set anything yet?
I'm Googling right now.
Okay.
Oh, great. Thank you.
What would be the proposed date of the first week? Because I would have a conflict.
August 20th?
Oh, August 20th? Or June?
Oh, June 18th. Is that what you're talking about?
No, I'm probably fine in August too.
Okay. And if you do have a conflict, it is okay to miss a meeting. It is also okay to call in, but you guys are always pretty good about trying to be here. So, and I don't like to miss stuff either. So I know I would want to be there, but it is okay.
Susan, I am seeing on the current Bentonville School District calendar, first day of school is August 12th, which is a Tuesday.
Oh, great. So the 20th will be after. Okay, perfect.
So y'all want to go ahead and put that as a tentative August date at least? Okay.
That's what that's what it's showing on this website right now.
August 20th.
Yes, sir.
I'm assuming we don't want to go into September yet, right?
We can if y'all want to. I mean, we can set the whole year if you want. I have no opposition to that. It's just kind of the feel. I know MMC really only sets like 1 or 2 at a time. I appreciate y'all at least 2, 3. But we can go as far as you guys want.
I'll give you a heads up. The only conflict that I know of in later 2025 would be the October 15th. It looks like I'll be traveling for work to Japan, both the 15th and the 22nd.
Fine.
So we might just do a sub for you.
Yeah.
Or you can call us from Japan, it's fine too.
Call from Japan. Yes.
That I join us on our Zoom call. And that's fine, Susan. I've got that down as a conflict for you. And again, if you need to miss one, please don't walk in the middle of the night. It's totally fine to miss one if you are. Anytime, but especially if you're in Japan.
I'll know closer to time if there's like a hearing or not.
Yeah, we will always try to keep you guys informed as well in advance as we know there's going to be a hearing. We'll let you know. Hannah texted and said she had to drop off. But I think other than that, we're probably good. Do you guys need anything else in our PowerPoints for next month or anything else you guys would like an update on that you haven't heard about in a while?
I think we're good on our end. So thank you for all your work these past few months. And,
Of course, the team, everybody. I mean, Potter's been hustling over there with me. Drew's been hustling over there with me. There have been days that we have supposed to have been in like 6 committees at a time. So we've sent Cameron, our tobacco attorney, to watch gambling bills. We've sent Drew to watch bank stuff and text us. We've had Chip in ag. We've had Potter asked to testify against him. I mean, it's been really, really a team effort. But I will say we couldn't have done it if we didn't have the support staff keeping the office running back here even. So it's been for sure a group effort.
Oh, one alcohol marijuana question. Wasn't there a bill to do like CBD in an alcoholic beverage? Did that get through?
That did not. That one was one that we were told was kind of watching a different hemp bill, and then that other hemp bill didn't make it through, and they kind of knew that theirs wasn't going to move. But that was one that we had been consulted on kind of beforehand, before it was filed.
Cool. All righty. Well, thank you guys.
I wanted to say thank you all for all your work throughout this legislative session. There's been just such a crazy high volume of bills to track, and you all have this steady focus and have helped keep us informed and everyone aligned, and it's made a real difference. So thank you.
Good. Well, thank you guys for showing up and listening. I know it's a lot to input, but if you guys have questions, please always call.
All righty. At this time, I think we can call the meeting adjourned. Thank you all for your time.
Sweet. Thanks, guys.
Thanks.
Okay, so y'all saw that there's gonna be a revocation again. I'm not gonna talk a lot about it, but we will let you know if we are expecting a lengthy.
This conference is no longer being recorded.